welcome everyone to the second session of the Indiana Leeds Summer Tax Workshop series. My name is Leopoldo Parada from the University of Leeds. I will be co-hosting today the series and also moderating the series. Leandra.
Okay, thanks so much, Leopoldo. Yeah, as he mentioned, he and I are alternating roles. So last week he introduced the speaker and I moderated, and this week we are doing the reverse. So he'll be keeping the queue and communicating with you in chat and all of that. So it's my privilege to introduce our speaker, the second speaker in the Indiana Leeds Summer Tax Workshops series. We're really lucky to have with us here today Stephen Daly. Steve is a lecturer in corporate law at King's College London, where he teaches EU tax law, the law of business taxation, and company law. His research considers the legal aspects of tax administration. And he was previously a lecturer in law at the University of Birmingham, and before that, University of Oxford, where he completed his doctorate on the rule of law implications of HMRC advice. So with that, let me turn it over to Steve to speak to us for about 20 minutes or so on his very interesting paper on tax administration.
Okay, thank you very much, Leo and Leandra, for putting this together. I think this really is a fantastic initiative. And I'm just looking now, and it seems that there's 95 participants here today, and I've never had to present anything in front of 95 people, so it's pretty intimidating. I'm going to try and share screen now. What I'll say at the outset, though, is that there are 3 ideas that permeate this paper. The first idea is the need for trust. We can't do everything in life ourselves, and sometimes we just have to trust other people to do it. The second idea that permeates this relates back to what Professor Mason said last week, which is once we elevate things to the international level, once you delegate responsibility for norm setting to the international level, you lose democratic accountability. But that gets you thinking, actually, are all the institutions, even at a national level, subject to democratic accountability? And tax authorities that are structured as non-ministerial governmental departments, such as we have in the UK, well, you don't have direct democratic accountability over them. So it gets me thinking more generally about accountability and what it means. And the third idea that permeates this paper is that there are aspects of life, social, political, economic, where we don't actually know the right answer. There may not be a right answer. So at the margins of state aid, I think that is when we're in the terrain of an area where we're not actually sure what the right answer should be. So those are the 3 ideas that permeate the paper. At the core of the paper is this hypothesis. I've got 2 variations here. The first is one that I've just put together for this presentation, and I think it actually better reflects what the paper is about. So the hypothesis at the core is that intelligent accountability provides a solution to trust issues. And this has particular relevance today in the context of the EU state aid investigations. Now, I put it a little bit more bluntly in the abstract, where I said the European Commission's rulings investigations are predicated on lack of trust in the tax authorities of certain member states. And the solution to this problem lies not in second guessing the work of tax authorities, but in ensuring that each is subject to intelligent accountability. So that is the hypothesis that's at the core of the paper. And the paper itself then is structured into 3 parts. The first talks about the need for trust. And I hypothesize that also at the core of the Commission's investigations into state aid, there is a lack of trust, or it evidences a lack of trust. In the second part, I suggest that the answer to issues in respect of trust lies firstly in intelligent accountability. And I'll explain that. And in the third part of the paper then, I look through different mechanisms to see whether they are appropriate means of achieving intelligent accountability. So the first part. Trust. So this is just about stressing that there is a need for trust, and I can't put it better than Professor and philosopher Honora O'Neill has put it, and O'Neill has won many prizes for her work on trust and is the foremost authority. She puts it as follows. At some point, we just have to trust. There is, I think, no complete answer to the old question, who will guard the guardians? On the contrary, trust is needed precisely because all guarantees are incomplete. And guarantees are useless unless they lead to a trusted source, and a regressive guarantees then is no better for being longer unless it leads to a trusted source. So trust cannot presuppose or require a watertight guarantee of others' performance and cannot rationally be withheld just because we lack guarantees. So there are things in life where we just have to trust other people. But what O'Neill says about that then is that, okay, I get that we need to trust people, we need to trust particular actors, but we shouldn't just give our trust over willy-nilly. We should actually place our trust intelligently in other people. So the proper assessment then ought to be in relation to trustworthiness. So I should place my trust in somebody if they are trustworthy. So they might be trustworthy in relation to particular tasks. So I think of my better half. She is an excellent lawyer, a really fantastic barrister. If I've got any legal issues, I'm going to her because I know that I can trust her advice. Whereas when it comes to minding our cat at the weekend, I'm not sure I can actually trust that she'll make sure that the litter is taken out, that the water is clean, that she is fed at her regular times. Okay, so I can intelligently place my trust in my other half when it comes to legal advice, whereas when it comes to minding our cat, I might try and micromanage, I might check in over the weekend a few times and make sure that everything is going to plan. So you can intelligently place your trust when you believe that the person in whom you're placing trust is trustworthy. O'Neill then breaks down two further aspects of trustworthiness. There is trustworthiness as to truth claims, and then there's trustworthiness as to competence and commitment. So with truth claims, you're asking, is what this person is saying correct? So my friend has a pair of binoculars and they're looking 100 meters ahead and they tell me that there is a rose bush 100 meters hence. Okay, I can take the binoculars and I can test the accuracy of that claim. So I can see, is that actually true? So those are empirical issues. In relation to competence and commitment, what we want to know is this person living up to their commitments? You said you were going to pick me up at this particular time. Can I trust that you will pick me up at that particular time? And competence. So is this person performing to the standards that we should be able to expect of them? When we think of tax authorities, there might be disagreement as to what we want our tax authority to do. But at a basic level, we know we want our tax authority to have sufficient staff and equipment to carry out the function of collecting tax. And we want to be sure that they do so impartially and objectively and free from bias. So that's trustworthiness. And we should place our trust when we believe that the actor is trustworthy. And we need to distinguish then two aspects of trustworthiness. Now, as I said, my first supposition in this paper is that the Commission's rulings investigations are predicated on a lack of trust. So by way of brief background, since 2013, the European Commission has been conducting investigations into various member states. It started off with Apple, and then it ballooned out from there. The Commission conducted an inquiry across the board into rulings practices that were conducted by member states' tax authorities. It's resulted since in several negative decisions against member states such as Ireland, Luxembourg, the Netherlands, also for Gibraltar, Belgium. I'm probably missing a few. And then there's been a couple of court cases. We've had judgment in Starbucks and Amazon so far. We're waiting on Apple. And there are a series of ongoing investigations also. Now, I suggest in the paper that the fact that the Commission has gone to these lengths is indicative that it just doesn't trust that tax authorities are conducting themselves objectively and dispassionately in relation to some taxpayers, specifically multinationals. And when you drill down further into that, I say that it is in relation to the trustworthiness of tax authorities to act competently and to live up to their commitments. The example I use is the Commission. Back on, and I'm sure. Okay, so I suggest then that the Commission's queries over the use of the transactional net margin method evidences this lack of trustworthiness in relation to competence and commitment. So very briefly, the transactional net margin method is a transfer pricing methodology which is one-sided. And the Commission openly explains that that's fine in individual instances, but we don't like it the way that it's been used here, 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 and here. Okay. And that suggests that there's something wrong with the organization of the methods of investigation and inquiry, which then brings you, or Nora O'Neill would tell us, to trustworthiness in relation to competence and commitment. So that's my suggestion. But by the way, I could be wrong. Okay, Margaret Vestager and the European Commission could come to me tomorrow and say, Steve, the investigation's got nothing to do with trust. You know, we love tax authorities in the EU. We trust every single one of them. And I can hold my hands up and I'll say, mea culpa, I'm wrong. Actually, you're completely right. There's no lack of trust in relation to that relationship. And I would still be right to suggest that when it comes to tax administration, there is this need for trust, because we simply cannot carry that function of collecting taxes out ourselves. We need to delegate responsibility of that task to somebody or to some actor. So there is a need for trust in relation to tax authorities. And specifically when we're talking about the administration of the tax code, this is a means by which particular actors can be favored over other actors. So if a tax authority gives a generous ruling to one taxpayer, that is a subsidy to them. And so that can amount to state aid. So I still would suggest that I'm right to say that this is an area where trust is still needed. We need to still have some kind of trust in relation to the ability of tax authorities to carry out the function of tax collection dispassionately, even if I'm wrong to suggest that that's what's motivated the Commission's investigations. So now I'll move on to intelligent accountability. O'Neill would suggest to us that intelligent accountability is the means by which we can assess trustworthiness. So it can tell us whether we ought to or ought not to place our trust in particular actors. She gets there by suggesting first that whatever mechanism you adopt to test trustworthiness, you must ensure that that mechanism doesn't actually distort performance. So we have examples from education whereby you set particular objectives for educational actors. In the UK, we've got the REF, which apparently measures the quality of the research that we engage in. But there is a question mark over whether that actually leads to a proper assessment of the quality of research, or rather it actually distorts research into fitting these specific objectives. So you want to have some mechanism for assessing trustworthiness that doesn't actually distort the underlying performance. We still want tax authorities to collect taxes. We still want them to do that objectively and dispassionately. Secondly, whatever mechanism you adopt must actually be one which facilitates trust rather than just being antithetical to it. So rather than being the opposite of trust. Now, O'Neill talks about managerialism in this respect. So setting targets, very specific objectives that go on top of everything else that the underlying actor is doing. Now, O'Neill says, well, that's just a continuation of management. If you're micromanaging, you don't actually trust the person at all. You're actually just taking away the need to trust somebody because you're doing the task yourself. Now, that doesn't seem to be a particularly good use of resources. And when it comes to tax collection, we know that we can't simply have two bodies doing the exact same exercise. There just isn't the resources in the world. So what we need then is intelligent accountability. Accountability which doesn't distort performance and which does actually lead to a rendering of an account which can tell us about the trustworthiness of a particular actor. So O'Neill then says that there are 4 conditions basically that need to be present, or that should be present. The first is we must be able to prove that whoever is acting, so in our case, the tax authority, that they actually do have some kind of duty to account for their actions. With tax authorities, we don't really have a problem in answering that question or meeting that condition, because we know tax authorities have some duty to account, whether that's to ministers in government, whether that's to the legislature, whether that's to parliament, whether that's to the public. And specifically in our case, when it comes to state aid, we know that tax authorities have to account for their actions to the Commission, because the Commission is under a legal obligation by virtue of Article 108 to monitor existing systems of aid. So there is that duty to account. When we talk about intelligent accountability, the person who is holding the other to account must be informed. So they must actually have sufficient expertise to be able to understand the underlying performance. Secondly, the actor who is holding the other to account must be independent of them, both institutionally and functionally. And the third thing is, whoever that actor is ought to be able to render an intelligible account of performance. So must be able to actually look at the performance of the underlying actor and say, yes, that person is performing up to the standards expected, or no, they're not, and be able to communicate that conclusion intelligibly to whatever audience needs to have that information. So that's the second part of the paper. And then in the third part of the paper, what I try to do is I try to assess different mechanisms for establishing or achieving intelligent accountability, and specifically in the context of state aid and tax administration. The first method would be bottom-up accountability. So it would be the public, NGOs, other taxpayers, everybody would be holding tax authorities to account in relation to the way in which they carry out their function of collecting taxes, specifically in the context of state aid. Now, the means by doing that would be by publishing all rulings, all tax rulings, all bespoke engagements between tax authorities and taxpayers to the public, having that publicly disclosed. But there are two questions in relation to that idea. So are these questions actually answered? And I don't think they are. First, if that information is disclosed to the public, is it actually intelligible in its form that it is given? If tax rulings or tax returns are simply published, I would suggest that that doesn't actually give full context to the public or other taxpayers, other NGOs, in order to be able to properly assess whether that means the tax authority is acting properly. So not only is the information itself incomplete, it also requires interpretation. So it needs to be disclosed to somebody who has the ability to understand it. And tax information itself is not readily understandable. You want to have some kind of a training or expertise in order to be able to understand it. So I don't think that that question is answered in the positive, in the affirmative. The second is, well, there's a question mark as to whether publicizing all of this information, disclosing tax rulings to the public, I think there's a question mark over whether that actually does hinder or augment performance. So whether that actually does distort performance of tax collection. So when we look to the empirical studies as to the connection between compliance and public disclosures of information, the empirical evidence is still mixed. So I don't think that those questions have been answered in the affirmative to sufficiently suggest that bottom-up accountability does render an intelligent account. Second method would be top-down accountability. So here I would envisage the European Commission acting up here and investigating individual tax authorities on a one-by-one basis. And that is what's already happening. We already have the Commission's investigations. Now, what I'm going to suggest here actually is further fleshed out in a separate article that I'd be more than happy to share with anybody. It's called The Power to Get It Wrong, and it's forthcoming next year in the Law Quarterly Review. but I'm not able to put it up on SSRN. So send me an email and I'll very happily send you that article. So I would suggest that when the Commission acts up here, it ought not to assess whether tax authorities have correctly applied the tax code to each individual taxpayer, but rather what the Commission should do is assess whether tax authorities have acted in compliance with the administrative law norms that are expected of them. So the fact that a tax authority may have misapplied the law on a case-by-case basis, that's not sufficient to bring about Commission intervention. Rather, what I suggest is the Commission should act when it can see impropriety because the tax authority is not acting objectively, it's biased, there are some irrelevant considerations that are taken into account. Those kinds of bits of evidence, once they're present, the Commission should intervene. And I've got reasons fleshed out in that separate paper as to why that ought to be the case. But at a very simple level, the Commission cannot act at a supranational level as a supranational tax authority. There aren't enough hours in the day, and there's not enough money and resources to do so. So I would suggest that the Commission ought to have, if it's going to act at a strategic level up here, that it ought to act in some kind of a restrained fashion. And I suggest that the use of an administrative law framework, it incorporates norms of competence and commitment, and it would, through testing through it, lead to an intelligent account of performance. So it's going to have to be reserved in some way. So what I suggest then is that perhaps the most fruitful avenue here would be through internal accountability. And this isn't a simple solution. What it requires is the Commission to engage in a lengthy and comprehensive study of the forms of accountability that are present in individual member states and to see whether those forms of accountability render an intelligent account. In the paper, what I use is the Finnish system as an example of best practice. In the Finnish system, what you have is a body called VOVA, V-O-V-A, and I cannot pronounce the full word. Now, VOVA is one body that sits within the Finnish tax administration, but it is independent of the tax collecting units. And what VOVA does is VOVA challenges individual decisions of the tax collecting units. So if you're a taxpayer in Finland and you go to the tax authority to get a ruling, what the tax authority will tell you is, okay, this is what we think the answer is, but just so that you know, VOVA might come along and challenge this. If VOVA thinks that we're being too generous, or if VOVA thinks that we're actually getting it wrong, if VOVA thinks we're getting it wrong and that's to the detriment of the taxpayer, they can also take a challenge against us. And VOVA then can challenge not only individual rulings, but also tax returns and so on, or tax inquiries and so on. Now, I suggest that VOVA does render an intelligent account because VOVA is informed. It is stocked with staff that are former tax inspectors, so they have the expertise and the knowledge to be able to hold the tax collecting units to account. They also have privileged access to information, so it's not just tax returns, but also it's all tax rulings that are sought. VOVA is independent institutionally because it sits separate from the tax collecting units, but also functionally, actually probably even more importantly, functionally. So we see from the reports that VOVA does actually act as a thorn in the side of the tax collecting units. And finally, VOVA does render an intelligible account of performance. VOVA produces annual reports which set out exactly what's happened during that year, how many challenges have happened, and also any broader changes within the Finnish tax administration. And when litigation goes all the way through the courts in Finland, we have judgments that also render an intelligent account of performance. So if I were to summarize them very briefly, it would be that in the context of state aid and tax administration, I believe that intelligent accountability is best brought about through a combination of internal accountability within member states, with the Commission then operating at a strategic level, taking litigation in individual instances where there's been breaches of domestic administrative law, and then also conducting this wide-ranging study to assess whether there are forms of intelligent accountability that are present in individual states. So thank you very much to everybody for listening. I'm going to try and stop sharing now.